Hey guys, it's Anthony Bandiero here. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, the nation's largest law enforcement legal trainers. And I'm bringing another roadside chat from the great state of Arizona. I'm in Surprise, Arizona, teaching advanced search and seizure, advanced criminal investigations, and bulletproof report writing for over the next 3 days. All right, so here's the question. If an officer has probable cause, and he conducts a knock and talk, can he arrest the person if he answers the door? Okay? All right. So the answer is probably no. And let me explain to you, okay? So first of all, we have a Supreme Court case that has told us that if the person is in the threshold of the doorway or out, right? Threshold of the doorway or out, then they are in a public place for arrest purposes. Now, public, use that loosely because they're not really in a public place. But what we are looking for is, the situation that's coming up is the guy answers the door, you have probable cause, you do not have an arrest warrant. If you have an arrest warrant, totally different ball game, right? You can serve it at their house. But he answered the door, and he's not in his door frame, he's just answered the door. Can you reach in, and I like to say body snatch him out of the house? I say no. Don't do it. Don't do it. Why? There is no exigency there, right? All you have is probable cause. The court is going to want you to go run to the courthouse and get pre-judicial authorization to reach into his house to grab him out. I know he answered the door, right? So maybe some people, and actually there are some people, they say, well, Anthony, some judges, but Anthony, he's presented himself to the world for arrest purposes, but the majority of cases would disagree with that, okay? Simply answering the door to cops to do a knock and talk does not mean you have availed yourself to be pulled out of your home by your shirt collar and arrested, right? I don't think that's reasonable under the Fourth Amendment. And remember just the incredibly high level of protections that courts will give to a home, right? The courts will say it's first among equals, meaning there is no equal. It's first among equals. There is no equal to the home. The home is the most protected. And we also have a Supreme Court case out of Kylo, okay, that said that 1 inch of intrusion into the home is too much without a recognized exception like exigency or a warrant or consent and so forth. So there's your answer, okay? I would not do it. I strongly believe that if the Supreme Court addressed that specific issue, person opens the door, you have probable cause to arrest, but you have no exigency, no public safety issue, no imminent destruction of evidence, no imminent escape if you don't act now. If you don't have something like that, leave them alone. Go get your warrant and come back. All right, guys, keep the questions coming. Join me on my free webinars every single week. Attend our live in-person and Zoom classes. Get trained. You cannot afford to make mistakes. All right, you got to understand what the courts are looking for here. You got to get trained. All right, guys, until next time, stay safe.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.